When an 18-year-old walks into a federal courtroom, you don't expect history to shift. You expect nerves, maybe confusion, maybe a young man caught in something bigger than himself. But when that 18-year-old is Barron Trump and he enters a federal court under subpoena, everything changes. Because that moment isn't just unusual, it's almost unheard of in American history. And what happened inside that courtroom tells us prosecutors have reached a point in their investigation that very few ever believed they would reach. They have gotten dangerously close to the decision-making core of the Trump organization. Close enough that they are now willing to weather the political firestorm of putting a former president's son on the witness stand. Here's the key thing people aren't understanding. This isn't about targeting Barron. It's about documenting the truth. A truth that, if proven, could reshape multiple criminal and civil cases all at once. I've watched political scandals unfold for decades. Watergate, Iran-Contra, the Clinton impeachment, financial crimes cases involving governors, senators, CEOs, you name it. The playbook is always the same. Prosecutors never bring in the child of a powerful figure unless they believe what that person knows is essential to proving someone else lied. And based on the documents revealed Tuesday, someone definitely lied. But before we get deeper into the evidence, we need to understand the atmosphere inside that courtroom. According to multiple observers, when Barron walked in, the entire room shifted. Not because he's famous, but because of what his presence symbolized. A line had been crossed. The investigation was no longer circling the Trump organization. It had entered the living room. The session lasted under 2 hours, but the impact was massive. Prosecutors introduced 47 separate documents, emails, texts, financial spreadsheets, internal memos. And each one chipped away at sworn statements made months earlier by senior executives. The first bombshell was the email chain from March 2023. Barron wasn't just a passive CC on a message. He was responding, directly and in detail, to questions about property valuations for Trump Tower. And not simple questions. Technical questions about square footage calculations, market comparisons, valuation methodology. If that sounds like business operations, that's because it is. Yet under oath, multiple executives previously testified that Barron was entirely uninvolved. They described him as a young man uninterested in the family business. They painted a picture of someone nowhere near financial discussions. And now, emails prove the opposite. That alone is enough for prosecutors to start building perjury charges. One proven lie under oath taints an entire testimony. Once you're caught in one lie, everything else you've said becomes questionable. And that's exactly what prosecutors want: pressure. But the second set of evidence made the atmosphere even heavier. Text messages, real, time-stamped messages, between Barron and Donald Trump from June 2023. In one message, they discuss accountants and making sure the numbers work. To the average person, that phrase sounds casual. But inside a federal investigation, that phrase is dynamite. It implies intent. It implies awareness that the numbers did not work as they were. And in fraud cases, proving awareness is often the hardest part. Prosecutors don't just want to show the numbers were false, they want to prove people knew they were false. Those messages move them one step closer. But then came the turning point. A Trump Organization accountant, someone who handled the numbers hands-on, was granted immunity 2 weeks ago. And with that protection, he testified that Barron attended late 2022 meetings where executives discussed how to present financial information to banks and insurers. Let me explain why immunity is such a big deal. Prosecutors only give immunity to people who were close to wrongdoing. Not to bystanders, not to spectators, to participants. If this accountant needed immunity, that means he believes he could have been prosecuted. And that means he's telling prosecutors exactly what they want to hear, because the only thing protecting him is total honesty. So, let's piece this together. The emails show Barron was involved in financial valuation discussions. The texts show awareness that numbers needed to be made to work. The accountant says Barron was in meetings about how to present those numbers to banks. When you combine all three, you get a very clear story. A story that contradicts sworn statements by others. And when sworn statements fall apart, prosecutors start knocking on doors. The question everyone is asking is, why involve an 18-year-old? Why make him testify publicly? The answer is simple. Because he is a witness, not a target. And because the documents show he has information that contradicts what others said. If prosecutors ignored that, the defense would argue selective investigation. So instead, they gathered every piece of information, followed it, and landed on Barron. But the real shockwaves started after the hearing. Within 24 hours, 3 congressional committees requested access to the documents. 2 banks announced internal reviews into Trump-related accounts. Insurance firms began reassessing risk exposure. Banks don't jump into political battles. They jump when they smell regulatory danger. And right now, the scent is strong. Because if financial statements given to banks were knowingly false, that's federal bank fraud. And banks are legally obligated to report potential fraud the moment they suspect it. Once banks are nervous, everything becomes unstable. Loan agreements, interest rates, credit lines, partnerships. Legal problems become financial problems. Financial problems become existential problems. This is how corporations collapse, not from court rulings, but from the pressure that builds before the ruling ever arrives. Politically, this lands in the middle of a presidential election cycle. Trump's base may not move. His opponents will amplify it. But the voters who decide elections, the independents, the moderates, pay attention to patterns of truth and deception. Even if this doesn't lead to immediate indictments, the drip, drip, drip of evidence, hearings, and financial reviews will keep Trump's legal troubles in the headlines throughout the campaign. And whether people like it or not, voters tend to gravitate towards stability during uncertain times. But let's zoom out, because the bigger question isn't about Trump at all. It's about the justice system. Can the law hold powerful families accountable when evidence points upward? Can prosecutors follow facts to their conclusion without fear of backlash? Or does political power shield people from consequences? This case is becoming the ultimate test. If prosecutors push through, follow the evidence, and secure cooperation deals all the way up the chain, it will prove that equal justice still means something. If political pressure halts the investigation, if witnesses stonewall successfully, if prosecutors back off, then the message is clear. Powerful people operate by different rules. That kind of message breaks democracies from the inside. Because once the public loses trust that the law applies equally, everything else begins to erode. Faith in institutions, faith in elections, faith in government itself. So here's where we stand tonight. Barron Trump testified. Documents contradicted sworn statements. An accountant has flipped with immunity. Congressional committees are circling. Banks are reassessing. and prosecutors have gained the leverage they need to pressure higher-level witnesses. This is no longer a small case. This is a legal, political, and financial storm gathering all at once. What happens next will reveal more about the future of American justice than any headline or speech ever could. Whether the law still holds, whether institutions still function, whether power still has limits, those answers will emerge from the ripples of Barron Trump's testimony. And the truth is, we're already watching the ripples turn into waves.